So welcome to today's webinar on corporate deals and new government approvals, a session that will explain the new UK National Security and Investment Act 2021. For those of you who don't know me, I'm Charles Livingstone. I'm a partner in the Government Regulation and Competition team at Brodies, and joined by Damien Ryan, who's a senior associate in the team. And Damien and I both specialise in competition law issues with foreign direct investment and national security clearances and the like, being a new, well, relatively new, but certainly expanding aspect of that practice. So what we're going to cover today, give you a little bit of the background to the Act. We will, or I will take you through some of the rules around the mandatory notification regime that the Act introduces. Damien will then say a bit about some of the sectors that are within the scope of that mandatory notification regime. We'll come back to me to talk a little bit about the government's power to call in deals that don't have to be notified to it, and then back to Damien to discuss how the government appears to be proposing to assess national security risk, both in terms of anything that's notified to it and in terms of deciding what deals it wants to review off its own bat. And as I said, we'll have some time at the end for questions. So the background to the Act. So we have the next slide, please. There have been various issues that have made the news recently in terms of often foreign investment, foreign involvement in key UK infrastructure. You'll recall the stories relating to Hinkley Point C nuclear power station going back a few years, which is being built with Chinese investment, and that was there was a lot of back and forth on that. There were special reviews carried out. Ultimately, the Theresa May government gave the go-ahead for that. I think to some extent that experience highlighted that the UK doesn't actually have a particularly sophisticated or well-developed regime for reviewing investment in key infrastructure, which is part of the contributing factors to the development of what is now the Act. Very high profile recently is Huawei's involvement in the UK 5G network, which eventually resulted in the government deciding to remove Huawei from the 5G network by the end of 2027, based on advice provided by the National Cyber Security Centre. So very much a sort of national security driven consideration there. The COVID pandemic has also thrown up some similar considerations in terms of the UK's resilience in relation to its health emergency response capabilities. So, for example, a concern that there's insufficient manufacturing capacity within the UK for certain PPE and other key items, and that the UK was too reliant on importing those products from other countries who, in the face of the pandemic, stopped that material being exported. There's also some talk, which has died down a little bit now, but certainly last year, of aggressive acquisitions. So people sort of snapping up key providers who were maybe struggling as a result of the pandemic. This consideration has dropped off a little bit, but it certainly informed the development of the legislation. So the next slide, we'll talk a little bit about the current intervention powers that the government has, principally to contrast those with how much wider the powers under the new Act are. So at the moment, the government is able to intervene in M&A transactions, essentially, on a number of grounds. One, and the one we're most interested in today, is the interest of national security. There are also various grounds relating to the media, the stability of the UK financial system, and as of last year, and connected to what I was just talking about, the need to maintain a UK capability to combat and mitigate public health emergencies. That's a very interesting topic of its own, but not within the scope of today. The regime for intervening in relation to those deals is pretty limited. The government's powers are restricted by reference to the thresholds for merger control. Initially, that was the usual thresholds of £70 million turnover, UK turnover on the part of the target, or a 25% share of supply test. Over the last few years, that the thresholds have been reduced for certain sensitive targets, particularly in relation to enterprises involved with goods that are subject to export controls, so military and dual use goods, computer processing, quantum technology, advanced materials, cryptography, and AI. The threshold there was reduced to £1 million. That's allowed for a bit more intervention, and we have seen some more intervention on the part of the government, but it is still a limiting factor. There's separately a regime that allows the government to intervene in deals that involve UK-based current or former contractors to the government with confidential defence information. That's not subject to the turnover thresholds, but again is not used very often. So on the next slide, some of the sort of drawbacks or weaknesses of the current regime relative to what we are about to have. There's no mandatory notification requirement. It's a combination of voluntary and the government taking action off its own bat after the event. There's a 4-month time limit that starts to run from the later of completion of the deal or publicity of the deal, which limits the time frame in which the government can act. The available remedy is blocking anticipated transactions or unwinding completed deals through forced divestment. That will be one of those remedies will be part of the toolkit under the Act. But at the moment, the regime currently has no penalties for seeking to proceed with a deal that perhaps shouldn't be proceeded with. It's also not been used very much. Most recently, public interest intervention notice has been given in relation to NVIDIA's proposed acquisition of ARM, which Damien will come back to later on. But that is only the 13th national security notice given since the regime was established in 2003. So that maybe gives you a sense of how rare they are. They have ticked up a bit recently because of the reduced thresholds, and just last week the CMA notified the Department of Culture, Media and Sport of another acquisition, Advanced Micro Devices, seeking to purchase Xilinx. But it is little used, and it's not, I think the decision has really been taken that it's not quite fit for purpose. So the next slide. We're going to talk a little bit now, or for the rest of the session, about the Act itself, National Security and Investment Act 2021. So that received royal assent just a couple of weeks ago, so it is now an Act, although most of it is not yet in force. It creates a new freestanding framework to assess national security concerns, and among other things, it will take national security out of the public interest intervention regime that we've just been discussing. So that current regime is kind of on its last legs, and it will be replaced in due course. The Act introduces a mandatory notification regime for key sectors with severe penalties for failing to comply with that. And it also gives the government a power to call in deals outside of that notification regime. And just one point that's very important to note, that power is available in respect of deals that completed from the 12th of November last year onwards. So it will be available retrospectively as an anti-avoidance measure. 12th of November is the day the bill was introduced into Parliament. So I'm going to take you through a little bit about how the mandatory notification regime works. So the Act creates a pre-closing mandatory obligation to notify deals. We've referenced there 17 key sectors. Damien will take you through those. That's not specified in the Act itself. The sectors are to be specified in secondary legislation, but the government seems pretty fixed on the 17 sectors it's identified. Leaving aside whether you're in one of the sectors, which Damien will take you through, there are rules about the level of control that needs to be acquired in order for the notification obligation to be triggered. So what we're looking at is deals that involve the acquisition of a right or interest that confers control of a qualifying entity. Now, it's a defined term, but it's so broadly defined, it pretty much means anything. So it's any entity that is not an individual person. It includes entities that are not legal persons. So it will include legal persons such as companies, but it will also include unincorporated associations if there happen to be unincorporated associations active in the sectors in question. The only other limiting principle is that the entity in question has to either carry on activities in the UK or supply goods or services to persons in the UK. But beyond that, it's an extremely broad definition. You're pretty much never going to get out of this regime by arguing you're not, that what you're acquiring is not a qualifying entity. There are various thresholds in terms of shares or voting rights. And each time an acquirer or an investor passes any one of these thresholds, there has to be a notification. So if somebody goes from 0 to 26%, that has to be notified. But even if the same person then goes from 26% to 51%, that's a new notification, and the same again at the 75% threshold. The bill, so when the legislation was originally introduced, there was a 15% equity threshold. That was the sort of the entry point for notification. That was removed in the House of Lords. I think it reflected a concern that it would impose too onerous a burden on deals at a threshold that was not as likely to produce concerns about the ability of somebody taking 15% to control the entity in question. And I think there was also a concern that that would end up in the government receiving far more notifications than was necessarily proportionate and than they might want to deal with. You'll see as we get to the call-in regime that nothing we're saying about the scope of the mandatory notification regime prevents the government proactively seeking to review a deal if they want to do so. What we're talking about now is deals where there is an obligation to notify it to the government. So as well as those thresholds, also any acquisition of voting rights that allow the person acquiring them to secure or block any class of resolution or an equivalent if it's not a company that's in question. So those are your sort of thresholds of control that you need to pass. There's no de minimis turnover threshold for a target for this notification regime to be triggered. The consultation in relation to the legislation, quite a lot of responses have suggested that there should be, but the government has taken the view that if the entity in question is within the key sectors and it meets the definitions that they've set out for those sectors, then it should be covered. Some of the sectors, as you'll hear from Damien, do have within them, the definitions have within them their own turnover thresholds, but there is no overarching turnover threshold that applies to all the sectors. So we'll move on to the procedure and timings for mandatory notification, which obviously if you're handling a deal, that's going to be very relevant to you. How long do you actually need to build into the timetable for this on the basis that you can't, or you certainly should not, complete prior to approval? So we will get regulations that will set out the form and content of a mandatory notice, which will be the mechanism by which parties will notify qualifying deals to the government. The government is able to reject a notice if it thinks it doesn't comply with those regulations, or if the government just thinks that the notice doesn't contain sufficient information for them to be able to carry out the review. And in that respect, this is very similar to the approach taken in merger control. So if you submit a merger notice to the CMA, it's up to the CMA to decide whether that notice is complete. And only once it declares the notice complete will its statutory time periods for doing its work kick in. So while there are time periods set down for how long this process has to take, ultimately the government is in charge of when that clock starts. So there's an element of uncertainty there in any timing question. But once the notice has been accepted, there's a 30 working day period in which the Secretary of State must either give what's called a call-in notice or confirm that no further action will be taken. And obviously what you will generally want is no further action taken if it's your deal that's being reviewed. A call-in notice is the process that triggers the assessment of a deal. What we're talking about here is how you get into that, the gateway for that through the mandatory notification regime. We'll come back to it a couple of other times, the issuing of a call-in notice. They all lead into the same process, but for the mandatory notification process, you get there through the mandatory notice. So if a call-in notice is given, there's an initial assessment period for the government of 30 days. The Secretary of State can give notice, creating an additional period of 45 days if the Secretary of State reasonably believes there's a risk to national security and the extra time is needed to assess that risk. And the parties can agree with the Secretary of State to have a further voluntary period. Why would you do that? Well, you might be concerned that the assessment is very complicated, and if you don't give the Secretary of State enough time to go through it and get comfortable with the deal, that rather than run out of time, they might just impose a restriction on the deal. So you might, in some cases, say, take your time, take a little bit longer, make sure you fully understand it, because we think if you do, that'll be better for us. The Act contains stop the clock provisions, so it allows the Secretary of State to issue notices requiring the provision of information and indeed evidence from witnesses in relation to a deal, and that's from the parties or from third parties, in fact. If a notice is given, then until that information is received or the witness shows up to give the evidence, the clock on these periods will stop. So again, the government, although there are prescribed timeframes, the government is very much in charge of not just them starting, but when they continue to run and when they'll be paused. So on the next slide, just summarise the potential outcomes under the call-in procedure. And again, this applies whether it's mandatory notification or another route. The two options essentially are the Secretary of State can give what's called a final notification. Actually sounds quite ominous, but in fact it is confirmation that no further action will be taken, so that's the good outcome. Or alternatively, if the Secretary of State is satisfied that there is a risk to national security arising from the deal, can make what's called a final order. And that order can impose a wide range of requirements to remedy the issue in question. And I'll just briefly read you the phrasing from the legislation. It says that a final order may include provision requiring a person or description of person to do or not to do particular things. And if that sounds very vague to you, then it's supposed to, because it essentially writes the government pretty much a blank check to put anything it likes in a final order in order to try and remedy the national security risk. And you'll hear some of the outcomes that those might include from Damien later on by reference to past cases. One provision of the Act that is curious is that it's possible for the government to provide financial assistance to a business in consequence of a final order that it places on that business. Now, that's certainly not something you see in relation to merger control or anything like that. Complying with merger control undertakings, the party does that at their own expense. I guess the thinking there is that if, for example, a business has to employ somebody who has national security clearance and will be accountable to the UK government in terms of reporting on what the business is doing and what it's up to, if you have to employ that person, then you're doing so in the interests of national security rather than in the interests of the business, and so the government should pick up the tab. So we'll see how that power is used, but I think that's the reasoning behind it. The key penalty under the mandatory notification regime is that any deal that should have been notified but isn't and completes will be void. Now, it's not clear what that will mean in practice. The Act doesn't really go into the consequences of that in any detail. It's fairly obvious to think that it means the various deal documents will be legally unenforceable, but what's less clear is whether it means that the deal will be treated as having never happened. We'll see how that plays out, but certainly nobody looking to do a deal properly will be keen to have their deal documents voided. It will be possible that's not a sort of permanent death sentence to the deal. It will be possible to validate a deal retrospectively and essentially make it put it in place again, so reverse its voiding. And the Secretary of State can do that through a validation notice. It can do that either if the Secretary of State becomes aware of the deal, then of a deal not having been notified that should have been, then within 6 months, Secretary of State should either give a validation notice or should call the deal in for review. And even if it's called in for review, can still be validated retrospectively if the Secretary of State decides that it shouldn't be blocked. And as well as the Secretary of State having that initiative, anyone who's affected by the fact that the deal is void, which is most obviously going to be the parties, but maybe others as well, can apply to the Secretary of State to validate it. Separately from the problem it will cause for the deal, if an acquisition should be notified but is not, then the company or the entity that acquires control without notifying will be subject to criminal sanctions or will be at risk of criminal sanctions. Similarly, the officers of that entity, so that's directors, management, etc., if the failure to notify is due to either sort of a negligence on their part, they should have known to notify but didn't, or a deliberate decision on their part not to notify, then they will similarly be subject to criminal sanction. And the penalties there are a maximum of 5 years imprisonment for individuals, or I should say, and an unlimited fine for an individual or for the entity in question. As an alternative to the criminal sanctions, it's open to the Secretary of State to impose civil penalties. So again, we're a little bit like the competition regime here. So civil penalties for not notifying a deal that should have been notified. The maximum that can be imposed is the higher of 5% of global group turnover of the acquirer. So depending on how big your group is, that could be a very big number indeed, or if that number is less than 10 million, then the maximum is 10 million. So these are pretty big numbers that are intended to dissuade people from failing to notify deals that they should notify. Okay, so I'm going to hand over to Damien now, who's going to talk about the key sectors that the government has identified.
Thanks, Charles. So the 17 key sectors. So as Charles has described earlier on, in addition to satisfying the thresholds and the requirements in order to qualify for a mandatory notification, it is also necessary that you come within one of the 17 key sectors. Now, the fact that you may fall outside the precise definition and are not required to make a mandatory notification doesn't mean that you avoid scrutiny of the investment security unit. They may nevertheless decide to call in the deal. But to be required for a pre-closing notification, you must come within one of the 17 sectors. The definitions, as they're currently found, are at the later stages of a consultation. So a consultation was put out last year, before Christmas, to public consultation. There were a lot of replies, and the government has now published what it believes is its near to final definition, but subject to further targeted consultation with specific stakeholders. At the end of that, then it will come into law when it's put in secondary legislation. So just to be careful that this is provisionally where we are for the time being, subject to the matter going into secondary legislation and then coming into force. Right, so there are certain sectors there which are marked with an asterisk, and they're the sectors which Charles would have referred to earlier on, where there's already been heightened scrutiny within the current framework. Of the remaining sectors, we are going to have a look at communications, transport, defense, satellite, space technology, critical suppliers to government, transport and energy, both electricity and oil and gas. But just to note that others include advanced robotics, civil nuclear, data infrastructure, and engineering biology. So moving on to the first sector then, which we're going to look at, which is communications. At this point in time, the definition is now confined to public communications. That's to say public communications networks, services, and associated facilities. Private such infrastructure is excluded. Notwithstanding that there is no de minimis turnover threshold, there is for communications, specifically in relation to network and service, which must have a turnover of at least 50 million. That also extends to associated facilities, such as mass and data centers, which are related to such a network, as will expressly, we have been told, submarine cables and landing stations and various digital infrastructure services. Nevertheless, there has a useful distinction been drawn between active and passive infrastructure, the latter being excluded on the basis that producers of ducts and poles do not cause a national security concern. There is, as I say, there's an ongoing consultation, and there's an indication that the government may take the step to list specific components which are captured or not by the definition, so as to avoid parties having to make their own distinction between active and passive. So the next slide will show defense. Unsurprisingly, defence has a very broad definition under the Act, or under the consultation as it presently is. It covers all activities that comprise and include the research, development, design, production, creation, or application of goods or services which are used or provided for defence or national security purposes. You will probably imagine that there is an overlap between this definition and export controls, which has its own section under the Act, but the defence definition goes much beyond that, is much broader. Just to note, the entity will be caught either if it is in relation to is a government contractor or any subcontractor. I flag that because that distinction is also important in critical suppliers to government, where different rules apply. So here, even if you are some way down the supply chain, nevertheless, if the ultimate beneficiary is the government, you could be caught. Or has been notified by the government that it holds or may come into possession of classified material as part of that contractual relationship. So you may not consider yourself to be involved in the defence industry, but if the government has said that you are in possession of classified material, it is possible you'll be caught by the definition, and that any potential deal will be subject to a mandatory notification. And somewhat related, to say that there's no safe harbour exemption for businesses that are not aware that they are making supplies for defence-related use. So the next slide, we'll look at satellite and space technology. This definition is quite comprehensive, and the replies to the consultation seem to be of the view that the definitions of the aspects of the industry were accurately and well categorized. So it refers to activities relating to space debris management, in-orbit servicing or maintenance, inter-satellite communications links, operating secure ground infrastructure and facilities, manufacture and testing of spacecraft, launch vehicles, satellites, space vehicles, etc. The use of space-derived data for any military or national security purpose, and the processing of space situational awareness data. Now, some of those definitions sound slightly general, if not generic, but the government somewhat acknowledges that by saying that the main issue is the potential for adversaries to use what might seem to be civil capabilities, but for military objectives. And that issue is repeated in a number of the definitions within the consultation, but in particular here on satellite and space technology. So the next definition being critical suppliers to government. This is one of the ones that was narrowed significantly on the second round of definitions. And it seems clear that it is critical suppliers to the public sector, but specifically with government. So reference has been made to the Public Contracts Regulations 2015, and government has the meaning of contracting authority within those regulations. That said, even though that's very helpful, that is still, or can be still, quite a difficult definition. And if you believe you may be caught by that, it's probably useful to get a view, because I know that can sometimes cause issues in the area of procurement. The qualifying entity must itself hold a contract with a public body. This is the distinction I drew a little earlier, where subcontractors or indirect suppliers are not caught by this definition. The primary criteria appear to be the security classification of information held by the target, or the clearances necessary to fulfill the contract. So once again, the target will know whether or not they have particular clearances in order to perform their job. And that criterion appears to be the primary focus of where the government is going with this. It's otherwise focused on the provision of physical, digital security to public authorities, That was once again slightly different in the initial consultation, but now appears to be narrowed to physical and digital security. So on transport, so transport can essentially be divided into airports and harbours. So on the maritime definition, it captures entities that own or operate a port or harbour that handled at least 1 million tonnes of cargo in the preceding year. That's helpful. I might have said at the outset that a number of the definitions can provide helpful guidance, but it's quite qualitative, whereas others provide actual metrics which are beneficial to clients in knowing whether or not they're going to be caught and obliged to notify. Transport is one of those, as is energy, as we'll see in a moment. But looking at transport, so the 1 million tonnes of cargo is anticipated to catch all 51 major ports. It doesn't make any reference to passenger capacity, which was initially part of the discussion. It also doesn't make reference to a special category of transported goods. Another issue which was considered was whether particular goods were especially sensitive from a national security point of view, and therefore even if the port wasn't busy, the fact that it was a conduit for that type of good, the port might be caught. But now we have a relatively straightforward a definition or criterion in the 1 million tonnes of cargo in the preceding year. It's not just simply the owners of the ports and harbours. It would extend to owners and operators of terminals and wharfs, which are within those ports. So looking then at airports, it will catch an entity that owns or operates an airport that handled at least 6 million passenger movements or 100,000 tonnes of freight in 2018. You'll note that 2018 is the chosen year because for airports, the 2019 figures are somewhat distorted given the COVID crisis. So we're looking back to 2018 figures to see whether the entity qualifies. Also, when we talk about operating, there must be overall responsibility for the management. So it has that qualitative control aspect in deciding whether or not you're operating an airport. And then finally, it captures the provider and owner of a provider of an en route air traffic control services in the UK. So something specific there. So the first of the energy slides relates to electricity. And once again, this is one where we're given specific yardsticks against which to judge whether or not an entity might potentially qualify. The government has been clear that they're not interested in retail electricity suppliers. The word electricity supplier had been heavily mentioned in the first draft, but that's now removed. And this new concept of an authorized electricity operator in Great Britain is introduced with two possibilities. One where the entity has individual assets that have or would have a total installed capacity of at least 100 megawatts, or alternatively, assets that, if added to those of the acquirer, and obviously they're related assets, would have a total installed capacity of at least 1 gigawatt. And that's halved since the previous consultation, therefore bringing more entities in, but at the same time, as I said, adding the qualifications in relation to retail electricity suppliers. Also, aggregators controlling GB assets with accumulated capacity of at least 1 gigawatt. Just to flag, you'll notice that I'm talking about Great Britain. Northern Ireland appears to be excluded, presumably on the basis that Northern Ireland forms part of a single all-island electricity market and has further complicating dimensions in relation to the NI protocol. So when I talk about the electricity energy definition for mandatory notification, it's GB I'm talking about. It includes licensed transmission and distribution operators, so those operators that are operating under a license from Ofgem, or the owners and operators of interconnectors. So the next energy slide, which is oil and gas, similarly captures licensed transmission and distribution operators for gas, owners and operators of gas interconnectors, long-range gas storage and gas reception terminals, entities that own or operate terminals upstream petroleum pipelines, and infrastructure, which are part of a petroleum production project. That also has a metric or a qualifying amount, which is if throughput is in the previous year was greater than 3 million tons of oil equivalent. But it will also catch any prospective terminal, pipeline, or infrastructure which has yet to come into operation, but would satisfy the greater than 3 million in its first year of operation. Also relevant are entities supplying petroleum-based fuels, whether importing, storage, production, distribution, or delivery. And they're caught if they provide or handle over 500,000 tons per annum, including owners of a downstream facility, which is caught if the capacity exceeds 50,000 tons. That was something which was increased from the original definition contained in the first draft of the consultation, increased from 20,000. So the call-in regime, back to Charles.
Thanks, Damien. Okay, so the government's ability to call in deals that don't necessarily have to be notified to it. So I'll say a little bit about the scope of that. It's very, very broad. The government can call in for review essentially any type of deal. The definitions are so broad that, again, you're very unlikely to be able to escape on the basis that your deal doesn't qualify. So the Act uses this term trigger event to refer to a deal where a person gains control of a qualifying entity or a qualifying asset. That can then be called in if the Secretary of State thinks it could create a national security risk. Qualifying entity is defined as previously. Gaining control of it is as before, so the 25, 50, 75% thresholds, but also for the purposes of this call-in power, gaining material influence over the policy of a qualifying entity will be caught. Now that's much vaguer than the thresholds for the mandatory notification regime. I think it's appropriate the mandatory notification not be vague if that can be avoided, given that people need to know when they should notify and are subject to penalties if they don't. But the addition of material influence for the call-in test gives the government a wider scope to call in deals that maybe are in the sectors covered by mandatory notification, but they don't quite trigger the thresholds. And again, overlaps with merger control there. Material influence is the test that the CMA uses. Qualifying asset, mandatory notification doesn't apply to asset deals, only to if you're buying an entity, but the government can call in the acquisition of assets. A qualifying asset, again, is defined so widely it can pretty much cover anything, but it's said to include land. So a piece of land that overlooks a sensitive MOD site, for example, might be subject to review. Includes any movable property, and those have to be either situated in the UK or used in connection with activities that take place in the UK or that supply goods and services to the UK. And you then have very broad definition, ideas, information, or techniques which have industrial, commercial, or other economic value. So some of the examples given are trade secrets, databases, formulae, designs, software. So it covers IP, but it may cover things that you would not necessarily think of as intellectual property either. And again, the only qualifier there is that they have to be used in connection with the UK in some way. In terms of when a person acquires control of an asset, well, they get that if they acquire a right or interest in or relation to it that allows them to use it or to direct or control how it is used. And that includes increasing someone's ability to use or control the asset when they already have perhaps a more limited ability. If they increase their ability, then that will also be a trigger event. And so the government might be able to look at that, or will be able to look at that if it thinks there's a national security risk. On the next slide, the timings. So the risk window here for deals is pretty wide. A call-in notice can be given within 6 months of the Secretary of State becoming aware of the trigger event. And awareness, you can deem awareness by the fact that it's been covered in the media, for example. You don't need to write to the Secretary of State to make him or her expressly aware of it. but there's 6 months if they're aware of it. If the Secretary of State doesn't become aware of it, there is a backstop of 5 years after the trigger event. So if the Secretary of State becomes aware of the deal 4.5 years after it completes, they still have 6 months in which to call it in, but there is that hard backstop of 5 years. But even that backstop doesn't apply if the deal should have been notified under the mandatory regime but wasn't. If a deal is void under those rules, then there's no limit of time on the Secretary of State's ability to call it in. I mentioned earlier that this regime has a retrospective effect. So any deals that completed from the 12th of November onwards, the day the bill was introduced into Parliament, the Secretary of State, if he becomes aware of the deal before the call-in power comes into force, then the 6-month time period runs from the day it comes into force. So the time cannot run out before the power to call in the deal comes into effect. And the 5-year backstop, again, comes from the date the call-in power comes into force if the deal completed before that. So that retrospective aspect is something to be kept in mind in relation to deals that either have already completed, although there may not be much you can do about that now, but certainly deals that are still in contemplation, this is a live issue. Okay, on the next slide, the procedure for the call-in regime, there is a voluntary notification process. Again, just like merger control, if you're worried that your deal will be called in, if you don't notify it, you have the ability to take the initiative. So the buyer, the seller, or the target entity itself can notify the Secretary of State of the deal. Again, we will get regulations that set out the form and content of a voluntary notice. Secretary of State has the same power to reject it if it contains insufficient information, so is again in control of the clock. But once it's accepted, you have it's basically the same process as under mandatory notification. 30 working days to either confirm no further action or give a call-in notice. If a call-in notice is given, then it's the same procedure, but there's no criminal offences or civil fines or anything like that underpinning this because it is a voluntary notification process. The parties will be able to notify post or pre-completion, at least from the buyer's perspective. The real value, just like in merger control, will be in getting pre-completion clearance, so that if the clearance is not forthcoming, if they've already completed the deal, then they're staring at having to divest what they've acquired at fire sale prices probably. Whereas if it's done on a conditional basis, then the worst case scenario is that the deal doesn't go ahead. If a deal has completed, there's the ability, just like merger control, to impose interim orders, most commonly hold separate orders that require the target and the buyer to be operated separately and not integrated. And if those are anything like the merger control orders, then those will be very onerous and not things that people would welcome having if they can avoid it. Okay, so moving on. Damien's going to talk to you a little bit about how we think the government is going to approach the risk assessment.
Thanks, Charles. So the first slide, what constitutes a risk? And we anticipate this to be of particular concern to parties, given that there is relatively little information in the public domain on precisely what is intended in relation to the approach to evaluating risk. So when I went through the mandatory notification definitions, there was extensive discussion on each particular sector. It's much more general in relation to the call-in power or platform which the government has. So as a starting point, where can we look to? So a statement must be made to Parliament on how the government expects to use the call-in power before it will be available, and there must be some consultation before actually making that statement. There is, however, a draft statement of policy intent available, which is probably one of the first port of calls if you want to assess how the government might view your deal and whether or not you would prefer to voluntarily notify it rather than risk the government calling it in. In that statement of policy intent, the government looks at 3 risk factors. The first being target risk. So in other words, the entity or asset which is subject to the trigger event, and whether or not that could be used to undermine UK national security. The trigger event risk. And that arises from the type of level of control being acquired and how it could be used in practice, whether or not it gives rise to some leverage which a hostile actor might have over the UK state. And then finally, the acquirer risk being the identity of the acquirer, which would give rise to concerns. Now, on the last one, the word foreign isn't used in the document, but I think it becomes quite clear that there's a pattern that this is aimed towards foreign investors, and then second of all, foreign investors with links to countries which have strained or difficult diplomatic relations with the UK. But I should say the risk factor, as described in the statement of policy intent, simply says that the government will look at the identity of the acquirer. So moving on to the next slide, we just have picked out a couple of case studies which we think might be instructive on how the government views national security, given that it has such a broad discretion, particularly under the call-in power. And the first one to mention is the Connect Bidco planned acquisition of Inmarsat. Now, jurisdiction there came before the CMA on the basis of the lower jurisdiction threshold, which Charles had mentioned at the outset. Subject matter was the type of thing you would expect the state to be interested in, strategic services and sensitive information, an ongoing contract with the MOD. And that acquisition was resolved through undertakings. And I think if we look at the undertakings very briefly, it gives an idea of what the government is thinking about. So first of all, the target was obliged to continue to supply the Ministry of Defence. The board of directors of the target was required to be made up of at least 50% of British nationals resident in the UK. And the target was required to employ a security controller who must be a British national with security clearance. So once again, when I said that there's no mention of nationality and of foreign in the statement of policy intent, I think that gives us an indication of what the government is thinking when you're talking about an acquisition. But once again, look at the countries that are involved, the UK, the US, and Canada. These are not countries that, well, the US and Canada are not countries we think of as hostile actors. And nevertheless, there are requirements about British nationals sitting on the board of directors. So I thought it was a good example to show that even though intuitively we think we know exactly where we're at on this, it may be a bigger issue than we think. The next one mentioned is the planned acquisition of ARM. This was mentioned earlier on by Charles. Once again, it's a sale by Japan's SoftBank to a US inquirer, and ARM being a global supplier of semiconductors. I think there it's maybe the subject matter, given that it's such a big player in the semiconductor market and that the semiconductors used in AI, quantum computing, and 5G telecom networks. So the next slide. So the next slide then refers to aerospace, to military-related deals, both of which were abandoned, both of which involved Chinese companies seeking to acquire entities within the UK, Imcross and Metis Aerospace. And in both instances, after initiating an investigation, the parties themselves decided that they wouldn't proceed, whether or not it was that the proposed undertakings were too demanding or for whatever reason. But that shows, I guess, a foreign investor, once again, not being able to proceed with a deal within the UK. So moving on to the next slide. So approvals are going to be handed by the Investment Security Unit. The ISU is a new unit specific to the purpose set up within BAYS, within the Department of Business. So the first question is how many of these notifications are they going to have to deal with? The government itself has said that it anticipated 1,000 to 1,800 mandatory filings every year. So that is deals which satisfied the critical key sectors requirement, which satisfied the thresholds and the qualifying entity requirement, which Charles described under the mandatory notification, which we would have thought was a considerable subset of deals which might potentially be notified to the ISU. The 1,000 to 1,800 figure was given when acquiring a 15% interest in a company could give rise to a mandatory notification. That has subsequently been elevated to 25%, and therefore one assumes that the number of anticipated filings would come down. But that said, that is the lesser of the notifications which we would have thought the ISU would have to handle. The voluntary notifications where parties seek reassurance or comfort, probably being the greater number. The ISU does not intend to publish full decisions on notifications. It had been anticipated originally that there would be a bank of precedent which we would be working from as the government told us how they were approaching each of these deals. They're being a little more reticent, although, and this is an issue which moved between the Commons and the House of Lords being amended from time to time, the extent to which the legislation would compel the state to reveal their thinking and their reasoning. Ultimately, where it settled was that final orders which are made by the ISU must state who is required to comply, who are the parties, what was the trigger event or entity or asset which was concerned, but also, and interestingly, include a summary of the order, its effect, and the reasons for it, and then include any other information the Secretary of State would consider appropriate. That really gives it back to the Secretary of State to be as liberal or not as the government wishes to be in coming forward with the reasoning for their decisions. So it's a little bit of a wait and see on that. And a further caveat to that point is that the legislation provides that the Secretary of State can withhold information that's likely to prejudice commercial interests or is contrary to the interests of national security. And once again, depending on how that's interpreted, we might find that the initial decisions are quite thin in giving future guidance, or they might be quite helpful, but once again, we don't yet know. So moving back to Charles.
Thanks, Damien. So I've got a couple of questions, but we've probably got time to take one or two more as well. So if you've got a question you want to ask, you've still got time to put that in. Take the first one. I think I'll pick this one up. So the 17 sectors mentioned include a number of areas where Scottish universities are actively doing leading research. The target entity arrangements will likely not affect technology transfer activities. Universities don't often do deals like that, but it seems clear that when universities license or assign IP or software, then the rules about assets could come into play. Questioner's just looking for confirmation that that's right. Yes, it is right. In the sense that the government's call-in power would be available because the definition of qualifying asset is so broad that I think it could cover pretty much anything they wanted to look at. But obviously it doesn't prevent that deal from going ahead, but it does mean that you would want to look at that deal and consider whether you wanted to proactively notify it and get it cleared in advance of going ahead with it. And I think if you're talking about assets, as the questioner says, they can't come within the mandatory notification regime. But I think the mandatory notification regime, you can look at that in an asset deal and say, if this asset was held by an entity and the entity was being acquired, if that would be subject to mandatory notification, that's probably a pretty good indicator that you should be thinking about notifying it because the government is likely to be interested. Question that you can maybe field, Damien, is there a risk that the Act could essentially be used as a vehicle to pursue broader industrial strategy considerations rather than simply national security?
Yes, there's been a lot of discussion around this, and I think that the reason that people are speculating so much is that the powers are so broad and the government is not as constrained as people might have expected. Yes, it identifies things which we associate with national security. But it goes beyond that. And it was interesting that early on, when this issue was raised, the Labour Party and the Commons suggested that maybe economic security should be something that was considered. And then people started asking whether or not issues of national security would be raised by trade unions, for example, where an acquisition might lead to a loss of jobs. Though I should say that that has been more speculation in the arena of public opinion. We don't actually have any reason to presume that it would be exploited as an industrial tool.
Okay. So another question, if a deal sector wasn't defined until recently and consultation remains ongoing, if a deal has been completed since the 12th of November and may now be in scope, what's the suggested approach? Damien, do you want to say a little bit about the ISU and its current activities?
Sorry, Charles, I was reading a question as you were talking. Can you give that one to me again?
All right, okay. So yeah, the suggested approach for a deal that has been completed since the 12th of November and that might be in scope of the mandatory notification regime.
Yes. So even though the mandatory notification regime is not already in being and the obligation doesn't exist, the unit I described, the investment security unit, has been set up, and we know that they are liaising with parties. They know that parties see that the consequences of being stopped, of being deemed to be in a mandatory notification, which should have occurred and which is a threat to national security, is so great that in order not to have a chilling effect on investment into the UK, they're basically saying, come to us, discuss with us, and we will give you some guidance. So if it is the case that you are the other side of the deadline, that you suspect that you are going to be caught by the mandatory notification, there is the opportunity to engage with the ISU to get comfortable before you conclude your deal.
Mm-hmm. And if your deal's already completed and you're worried about it being called in, then there's probably a judgment call to be made whether you approach the ISU to try and get some comfort that they won't call it in. You might do that in order to get that comfort, but by the same token, maybe you don't want to poke the bear. So I think that's at the risk of sounding self-serving, I think that's a matter for advice in this specific case. Okay, another question. If a supplier, so this is about critical suppliers to government, I've got the definition here so we can deal with it quickly. If they don't provide physical or data security, do you still look at their security classification? So you do. These are separate categories. So even if a supplier doesn't provide physical or digital security, if they are involved in contracts with government that involve security classifications, then they can still be caught. And the question is, where's the range? So if they're involved in processing or storage material that is secret or top secret, if they need to have List X accreditation, or if their employees need to be vetted at or above security check level, that's when it kicks in. And those levels were raised from the original consultation, so it won't catch as many deals as it did before. Another question, just to close it off, I think about timings. What are we expecting in terms of this coming into effect? So the government's documents say that they are looking to get everything into place for the regime to be up and running by the end of the year. I think the earliest I've heard speculated about is about September. That seems to me quite tight because they do have to make a lot of secondary legislation, and they will also want to they should give people a little bit of an opportunity to familiarize themselves with what's going to come into force before it comes into force. But by the same token, and this is reflected in the retrospective application of the call-in regime, they don't necessarily want to hang about in terms of getting these rules in place, particularly while they are still issuing public interest intervention notices. So it's not an issue that's going away, and they won't hang about, but hopefully there will be sufficient time for people to get used to what to actually expect. Okay, so I think that's us pretty much on time, so we'll wrap up there. Our contact details are on the slide. As I said at the start, you will get a follow-up email with a link to the recording if you want to watch it back. But before or after you get that, if you have any questions that you would like to put to us, we are very happy to assist. You've got our contact details there, so don't hesitate to get in touch. And otherwise, thanks very much for your time, and hope to see you again soon. Thank you.
Thanks very much.